Misty Marris joins us, trial attorney, legal analyst. David Weinstein as well, former federal prosecutor. Welcome both. All right, David, you first on the gun case. So it was 8-1, right? Only Clarence Thomas, he was the one. What did you make of that ruling?
Well, I think this again shows the justices looking at the original documents, what the intent was, and finding a way to include changes in both circumstances and the law that allows them to say, look, people have a right to possess a firearm, but the state and the government have a right to step in if they feel that there's a danger presented to others by the fact that these people would possess a firearm. And that's what the majority of the court said in the opinion. Thomas dissenting. There were a couple of interesting bits of language in there. One was in the majority opinion that says, look, we can't just look at the words that are in the amendments or the Constitution. Otherwise, we would have been talking about muskets and rifles.
Right.
And that there was a valid reason here to restrict this particular individual's right to possess a firearm because he presented a danger to others in the community, and that is not inconsistent with their other rulings. So I think it shows that the conservative and liberal justices can work together. And again, goes back to what we've been talking about over the course of the last couple of weeks, Connell. How are they going to interpret the original language in these documents as it will apply to that one case we're all waiting for?
Yes, we didn't still get an answer on Trump immunity today, but the use of kind of common sense, to your point, in this case was interesting, Misty. It was Chief Justice Roberts writing for the court. We'll put up that opinion that David was referring to, or part of it. The Second Amendment, the Chief Justice says, permits more than just those regulations identical to the ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. As we explained in Bruin, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. So there's always a lot of legal language, but then sometimes you read through it and say, yeah, that kind of makes sense. So what did you make of it, Misty?
Absolutely. So the Bruin case, which was just referenced in the opinion, really expanded Second Amendment rights. And so it was really unclear where the court was going to go on this case, even though, to your point, Connell, it seems like kind of a common sense type of thing that somebody who is engaged in domestic violence should not have access to a firearm. But the Bruin case was so expansive, and now there's this carve out relating to the possession of a gun of somebody who is potentially dangerous. And the court looks back at history and looks at historical context and says, we have to find a way to have this make sense with also taking precedent in history into account. And as Amy Coney Barrett said in her concurrence, the Second Amendment is not absolute. And basically, yeah, we're looking back at the language and the text, and of course that's important, but we also have to realize it's 2024 and be a bit more practical.
Yep, not the 1790s, it's the 2020s, and we apply it to now versus then. And yeah, that's an interesting, and to David's point, what does that mean for some of the other cases? We'll see. Now, this other one, that's just getting more attention, the gun case, I think, than the case I referenced on marriage. But there is an interesting component in the dissent on that. Misty, I'll start with you on this, then go back to David. The Supreme Court, it was 6-3. U.S. citizens have no constitutional interest in their non-citizen spouses being able to enter the U.S. The dissent came from Justice Sotomayor on this. So let's put up that dissent for a moment, and then we can get into what the wider implications might be. Today, the majority fails to live up to that centuries-old promise, she writes. Munoz may be able to live with her husband in El Salvador, but it will mean raising her U.S. citizen child outside the U.S. Others will be less fortunate. The burden will fall most heavily on same-sex couples and others who lack the ability for legal or financial reasons to make a home in the non-citizen spouse's country of origin. For those couples, this court's vision of marriage as the assurance that while both still live, there will be someone to care for the other rings hollow. So this idea that this might apply to marriage equality, Misty, what did you make of that?
I wasn't surprised to see that in the dissent because, as we know, in any Supreme Court ruling, even though the factual circumstances might seem quite narrow, the implications of the decisions are actually very broad. And so after this decision, you're going to see different legal challenges cropping up in different states, going through the federal court system, that are going to take those principles as set forth in this decision relating to marriage and applying it to other aspects, not just this particular issue relating to citizenship. So the idea is that it's going to be a more expansive doctrine that's going to be tested now in other ways and in other circumstances.
David, thoughts on any wider implications of this ruling?
Well, I think Misty hit it right on the head. Look, we saw a lot of this when the gambling opinion came out, and connected that to the marijuana opinions that have been coming out. And it's not just related to the single issue that's being argued, but rather what's the implication? How can I apply this to another situation, use it either for the benefit of my client, or if I'm the government, say, well, no, this law restricted this certain area but expanded others. And it allows for these opinions to have a broad effect and not just on the narrow issue they decide.
Let's talk about Donald Trump for a few minutes now before we go, because like you said, David, earlier, we said, well, maybe today will be the day we get the immunity hearing. No, we have a hearing in the classified documents case in Florida. We'll get to that in a few minutes as well. And then we have the gag order. So Alvin Bragg, the DA, is asking to extend the Trump gag order, which leads us, I guess, Misty, also to the 11th of July and sentencing. Gag order still in effect. Update on what this means, you think, and where we're going on the 11th.
Well, Donald Trump, of course, had said that now the gag order really there's no validity to it. And it's because the purpose of the gag order, which was limited to begin with, was to protect the jurors and to protect witnesses so that they could testify unfettered without fear of retribution and about fear of being unmasked. So all of that isn't really relevant now that we're going to the sentencing phase. Now, the district attorney in the filing today said that there's still significant risk and issues relating to his Donald Trump's supporters, and there's the threat on that front. And so he's using that to say that there's gag order. I do. I actually think that I was surprised to see that the gag order was not lifted after the guilt phase of the trial. But it's really up to the judge in his discretion, and judges have a lot of discretion on this point. And every single time Donald Trump has challenged the gag order to the appellate division has found that it's within the judge's discretion. So we'll see what the judge does with that.
What do you think, David? Or would you make the case for a gag order that should still be in effect, that there's reason, or you agree with Misty that Bragg is kind of stretching here a little bit?
I think that Bragg is trying to stretch it a little bit, but his stretch today kind of ties in with this gag order that they're looking to impose down here in Florida, where the comments aren't just affecting, in the case here in New York there, the jurors who would have been involved, but other people who are involved with it. I think it's a stretch, though, for Bragg to somehow say that it's affecting other people who are involved. Look, he has always been allowed to be put in the spotlight, as has the judge, so that wouldn't affect them. But if you tie it into what's going on in Florida and the gag order they're going to argue next week, where Trump makes statements about law enforcement and the way they acted, and then it has this effect on his supporters, some of which, sort of ties back to what the whole theory was in the January 6th prosecutions and the case in D.C. So it's this one big web of Trump that sort of gets engulfed within itself.
All right, David, thank you. One big web of Trump, and Misty as well. Thanks to both.